Welcome to the Court Assistant Exam Preparation class sponsored by the Gay Straight Alliance of the Unified Court System. My name is Mark Spiritus, and I'm a retired senior management analyst who worked for the Unified Court System for many years. I will be reviewing the different types of questions which are found on the Court Assistant Examination. You should have a copy of the accompanying New York State Court Assistant Exam Review Manual presented by Dynamic Training Consultants, and you should follow along with the different sections of this presentation. Please note that this is a very difficult and competitive examination, and it is designed as such to bring the very best minds into the Unified Court System. Before we begin, the Alliance wishes to thank Executive Director Erin Urban and her assistant Dawn Daniels of the Noble Maritime Collection for the generous offer of a facility to record this review. In addition, we wish to thank Assemblyman Matthew Titone and his chief, Chris Bauer, for their assistance in making this presentation come to fruition. Finally, I wish to thank Mr. Albert Albanese for his technical services in recording and editing this review, and Mr. Mark Levine, past president of the Alliance, for all of his efforts in putting this together. We're going to start with the section on legal terminology, which begins on page 4 in the manual. Okay? One of the most important and direct ways to improve your reading comprehension is to increase your vocabulary. And in addition to the fact that there is a separate section on legal terminology, you working on this section and increasing your comprehension will also assist you in doing better on the other parts of the exam, especially the part that's applying facts and information to given situations. A solid understanding of legal terminology will help you in many different ways in different sections. And you must increase your vocabulary, especially if you don't have any experience working with this legal terminology. So I'm going to be reviewing the terms in the legal dictionary, which begins once again on page 4. Okay, I'm not going to review every one of the words in this dictionary. I'm going to just talk about some of them so that you understand some of the nuances involved in the understanding of what each concept is. So we're going to start with the word acquittal. An acquittal is a verdict of not guilty. Okay, please remember, and I've seen this in the past on other exams, that a verdict of not guilty is not a verdict of innocence. Nobody finds in our courts a verdict of innocent. There are guilty, not guilty, and there is also an additional one, not guilty by mental defect. Okay? The second word I'm going to do is action. And an action is a lawsuit or proceeding taken in a court of law. An action, generally speaking, refers to civil types of cases. And there are many types of cases of actions. Basically, they're divided into two types, and that's criminal and civil. And we'll talk more about the different types in a few minutes. But just remember that family court actions are considered civil actions. So basically, everything would be divided into civil and criminal. The next word that I'm going to talk about is an affiant. And an affiant is somebody who signs an affidavit. An affidavit is signed under oath. Somebody has to take an oath to do an affidavit. Now, I'm going to bring this up right now because there are two words that are used interchangeably among most people, and that's affiant and deponent. So an affiant swears to the truth of an affidavit, and a deponent swears to the truth of a deposition. And the technical difference is that an affidavit generally is an ex parte document, which means you get it signed before a notary or somebody else who's authorized to take oaths. A deposition is signed usually in front of both sides. So a deposition, let's say in a criminal matter where you're called in to give a deposition, or even in a civil matter, both sides will be present, either the people with district attorney in a criminal case and the defendant's attorney, or in a civil case, the plaintiff and the defendant's attorneys. So there is a technical difference between the two, and should it arise on an exam, just know that an affiant does an affidavit, and that's an ex parte document generally. A deponent is it signs and swears to the truth of a deposition. That's usually both sides present. The next word I'm going to talk about is an appellant. When you're not satisfied or somebody's not satisfied with a particular case, they appeal the case. You don't have to know the specific rules about the appeal, but you should know the nomenclature or terminology that the appellant is the person who contests it. That person could be either a plaintiff or a defendant. So a defendant can be an appellant also. Don't get into the habit of thinking only this person who starts the lawsuit can start the appeal. It can also be a defendant. All right, so that's an appellant. The person who is sued in the lawsuit, in the appeal, is the appellee, and that's the party upon whom an appeal is taken. So just know this general terminology. Once again, the appellee doesn't have to be a defendant. It could be the plaintiff. It's the person who's not satisfied with an original ruling. The next word I'm going to talk about is arbitration. Arbitration is a submission of matter to a selected person, either voluntary or not, as opposed to a judge. Most of you know about arbitration, and in the news today you'll see that people are fighting arbitration in the sense that when you take a consumer credit agreement with an agency or a corporation, they usually make you sign a kind of a waiver of your right to go to the courts, and you are forced into going to arbitration. So that's really where it is in the news now, that you can't take them to court because you've signed the waiver of that right. And so that's where you hear arbitration more. But there are very different types of arbitration. Just know that arbitration generally means you're not going to go before a judge. You're going to go before somebody other than a judge. And in many cases designed just to save the courts their limited resources of judicial officers. The next word I'm going to talk about is a bench warrant. A bench warrant is something that is basically a bench warrant is an order of a judge in the court system to certain people to go out and take them into custody so that they lose their freedom and they're basically brought into court. Sometimes they miss a court appearance. There are many different reasons. But the bottom line is there are different types of warrants, but a bench warrant is issued by a judge to bring somebody back into court who's not following the rules or order of a judge. The next word I'm going to do is calendar. A calendar basically is a schedule of cases or matters to be heard in court. It really is just a list, and many calendars are posted outside of courtrooms throughout the state of New York, and they're just a list of cases to be heard in that particular part of court. The questions on the exam that will be dealing with the tables may have information from calendars. Which cases were tried, which judges tried which cases, totaling up number of cases on calendars. But just understand that a calendar is similar to a calendar that you're used to with dates and months, and no courtroom in New York State operates without a calendar because cases are adjourned all the time, and there are certain statutory requirements that judges have to follow in terms of the length of time before adjourning a case, trying a case, etc. So calendars are very important. A calendar call is very simply just the oral calling of a calendar in a courtroom or another facility like a courtroom. But the bottom line is somebody, usually a court officer or a court clerk, depending on the court you're in, will be calling the names, and then they will be handling the cases on the calendar based on the names that are called. So that's a calendar call. The next word I'm going to do is a commitment. Okay, a commitment has a specific legal meaning, and that basically means it's an order by a judicial officer basically directing confinement. So somebody is committed. It means they're not going to be out on bail. They're not going to be released on their own recognizance or free without any conditions. A commitment means they're going in. So that's what it means. It's a little different from other meanings that it may have in the English language, but that's what it means in legal terminology. The next word is called a conviction. And a conviction is either an enter of plea of guilty or a verdict of guilty. Both have the same effect, which means if you plead guilty or you get a verdict from a jury, It both is equals to a conviction. So just know that. The next word I'm going to do is crime. Crime is an offense which is designated in law to be a felony or a misdemeanor. You don't have to know the specifics of the time and sentencing that can be offered in these particular cases, but just know a crime is a felony or a misdemeanor. It does not include a petty offense, which is a minor offense, basically. A decree. A decree is a determination made in surrogate's court. It's like a judgment in civil courts. A deposition I spoke about before when I basically distinguished it from an affidavit, and it's sworn testimony of a witness taken of a deponent. And as I said, a deposition is generally with both sides present in either action, civil or criminal. Disposition. A disposition is the end of a judicial proceeding, could be by orders, judgments, or sentences in criminal matters. It is measured, and it is likely this particular one is very important to understand that a disposition is really, number one, what attorneys and the people of the state of New York in criminal cases are trying to get. They're trying to get a disposition. In civil cases, basically they're trying to get a judgment. In criminal cases, the person who takes the case is a district attorney or an assistant district attorney, and their intent is basically to get a judgment, but really a conviction. That's what they're aiming for. Okay, docket. The word docket basically has two general meanings. It's a document that summarizes a particular case. That's the first meaning. The second also is an identifying number of a case used in certain courts. And although they have come and changed it a lot and introduced other names, a docket number is usually given to a case, and it identifies that case specifically as different from other cases, and it's unique, like a social security number. It's an identifying number. The next word I'm going to do is ex parte. An ex parte is done by or for the benefit of one party only. Exclusionary. Basically, it's exclusionary of an adversary. So ex parte means that one side, a plaintiff or defendant, the people of the state of New York or the defendant, one party is communicating to somebody else. And just so you should know, as an aside, basically ex parte communication is prohibited by the rules of the chief judge, so that one side should not be speaking to a judicial officer about anything substantive about a case ex parte. And that's really the important thing to understand, that both sides generally have to be present to present anything to a judicial officer. The next word I'm going to do is felony. And a felony is defined, once again, it's a crime like a misdemeanor, and it's punishable by more than 1 year in jail. So that's really the legal technical definition of a felony. You may see on the exam different degrees of crimes, and generally the degree of crime determines whether or not something is a felony or a misdemeanor, and they have different levels of felonies, A, B, C, D, E. So those levels will determine basically how long somebody can serve when they're sentenced by the judge. The next word is finding. And a finding is basically a decision on issues of fact versus law. And that's really all you have to know. Sometimes judges will not determine everything in a case. They will only determine the law, but sometimes they will give the case to a judicial hearing officer or someone else, and they will find findings for the judge, and the judge then will make a determination on those findings and the law and make a determination. The next word is hung jury. A hung jury is a jury whose members cannot reach the required agreement for a legally sufficient verdict. And you don't have to know, but basically in a criminal case, the requirement is that it is unanimous, and in a civil case, it is 5 of 6 in New York State for civil cases. But a hung jury is one in which those particular requirements are not met. The next word is index number. An index number is a number issued by the county clerk to identify a civil action. So every individual civil action will get an index number by one of the over 60 county clerks in the state of New York in each county. An indictment is a written accusation by a grand jury charging one or more persons with the commission of at least one crime. That's the definition of indictment. Sometimes it is also called a true bill. An indigent. An indigent is an individual who lacks funds to retain private counsel. People come to court, many people who do not have the money to prosecute or to begin an action. And in civil cases, an indigent has the right to apply for what's called a poor person's order, so that the state will pay for that person's lawsuit. That's basically it. An injunction. An injunction is a court order directing a person or an entity to stop or start performing a specific act. It's usually used in cases where people need immediate relief, so they don't have time to go through the usual prescribed time for commencing a lawsuit and going to trial. People will come in and get an injunction or restraining order. Joint trial. A joint trial is a trial where multiple actions are tried together at the same time. That is a joint trial. A judgment. A judgment is the final determination of the rights in an action. And that's important to note, because once again, a judgment determines the rights of the parties in a case, and that's what people generally in civil cases, they're aiming for. They're aiming to get a judgment so that they can collect or get whatever they have sued for in the action. A jurat. The jurat is very important. It's in notarized documents, and it is the certificate of an affidavit stating when, where, and before whom it was sworn. So on all affidavits and sworn statements that are reduced to writing, you will see a jurat which says subscribed and sworn before me on a particular date at a particular county in the state of New York and at a particular location, and will have the name of that officer and the signature. So that's what a jurat is. It's that part of the affidavit or the notarized document. Jurisdiction. Jurisdiction is the geographical area, subject matter, or persons over which a court may exercise its lawful authority. That's a pretty common word, and it can be, once again, there's geographical jurisdiction, there's subject matter jurisdiction, there's personal jurisdiction. You don't have to be an attorney to take this exam, but understand jurisdiction in any one of those cases basically means that the court has the right to exercise its legal authority over that person and that particular location and the subject matter of what they are suing for. A lien. A lien is a legal claim on the property of another person. They lien people's property, means basically you have a judgment against somebody, you put a lien on their property, generally means that they can't transfer that property without satisfying that lien. Locus sigilli, that's Latin, and that means the place of the seal. So that's where the seal goes on a document. Minutes. The minutes are the recordings of proceedings. That means that, generally speaking, in proceedings in courts in the state of New York, there are recordings done by a court reporter in most cases. Nowadays, in many cases, they are also created by auditory recording equipment, and that is reduced by somebody who transcribes it or transposes it into the English language. So minutes are the recordings of the proceedings, and they cost money for people to get, and they're a very big part of the cost if somebody does take an appeal, just so you should know that. A misdemeanor, as I said before, is a crime punishable by imprisonment of more than 15 days, but not more than 1 year. And as I said before, crime includes a misdemeanor or a felony. A motion. A motion is an oral or written request for to the court for a ruling. So basically, a motion is a request by a person to the court, whether it's a judge or a judicial hearing officer, a referee, for an order of the court. It's just a formal term for that, and it can be in writing and it can be oral. So you can make a motion in writing, a formal motion, or you can make an oral motion on the record in open court. A movant. The person who initiates the motion is a movant. Once again, this can be a plaintiff, a defendant, it could be a district attorney, it could be anybody in the court, but the person who does it is called the movant. Just like the appellee is not the person who starts the appeal. The appellant is the person who starts the appeal. The next word is nunc pro tunc. That is a legal term from Latin, and it means now for then. That's all it means. Basically, it is something, an order from a judge or a hearing officer that allows a particular force to have an effect in the past. So if you issue it now for then, nunc pro tunc, you could say, okay, something wasn't filed properly now, in the past. So a judge can issue an order saying, we allow it to be filed nunc pro tunc, now for then. So at the beginning of the year, I'm allowing it to be filed right now, nunc pro tunc, for the beginning, for January 1st of this year. That's all it means. Go back and be retroactive, have a retroactive effect. The next word is part. Part is a very important word. You may see it in other parts of the exam. Part is basically a courtroom where cases are heard. And in many courts, you call it a courtroom. It could be almost like a large closet, especially in some of the housing courts. But a part is basically a courtroom. If you watch TV, you'll see Law and Order. You'll see they always film outside of the courtroom, and it will have a number, part 100, part 70. It can be a number designation. It can be a letter designation. All it means for your purposes and for the exam is it's a part of the court. That's what it means, a designated area where some kind of judicial proceeding is going to take effect. And on the further part of the exam, on the table questions, you will may have information that lists the parts. And so just remember, it's just a part of the court, and it's like a courtroom, basically, and that's what you have to know. And, basically, they have calendars called, they have hearings in there, they could have trials in there. There can be many things going on, but it's a designated breakup of the court, of different parts which make up a particular court. The next word is a petition. And a petition is a formal written request to a court initiating civil special proceedings and family court proceedings. So basically, it's used in two types of proceedings, which are called, and you don't have to really know this, but just to understand it, petitions are used in certain courts. In Supreme Courts, they're basically for a special proceeding, which is a type of proceeding in civil court versus regular lawsuits. And in all family courts, they begin with the petition. So that's a petition. The next word I'm going to go over is res judicata. Res judicata is another word that comes from Latin, and it's basically a controversy that's already decided. So in other words, if somebody is asking for something to be decided by a hearing officer or judge, and it gets determined that it's res judicata, it means that has already been decided in the past. It's a nullity because it's already been decided. There's no need to decide it now, basically, because it's already been decided. They use that term, res judicata. Next term, respondent. A respondent is basically the party who is being sued in a special proceeding, and also the party against whom an appeal is being taken is called a respondent. The party against whom a proceeding is brought in family court is also called a respondent. So whereas you have plaintiff and defendant in civil cases in Supreme Courts and civil courts, and you have the people of the state of New York against the defendant or defendants in criminal court, in special proceedings, you have a petitioner and a respondent. In family court, a petitioner and respondent, and sometimes called a respondent in appeals courts, such as whatever, the appellate division courts, and an appellant will take an appeal, an appellee will be the respondent in an appeals case. The next word is a summons. You should be very familiar with the word summons because it really is applicable to almost all the courts in the system, but it has two major meanings. One is a process by a criminal court directing an appearance. So you get a summons to appear in court, just like you would get a traffic summons. You can also get a summons to appear in court. But more importantly, in legal proceedings in civil courts, in civil proceedings, it directs the response and it commences an action. So summons could mean two things. One, summoning someone to come to court, whether, for something minor like a traffic offense or something like that, even something that has to do with Department of Transportation, Department of Sanitation. People get summonses to come to court. In civil proceedings, a summons is a major, basically, document which commences the proceeding and it directs a response from someone who's being sued. So there are two different meanings of the word summons, and you should be aware that it does have two different meanings. The next word is the word tort. A tort is basically a civil act or personal act that results in an injury. So basically, a lot of the civil courts, a lot of the actions in civil courts are torts. They're personal wrongs that are done by people, as opposed to criminal wrongs. In a criminal case, it is the people of the state of New York who have to take the case. That's what they're instructed to do. So tort is a civil wrong or a personal wrong. In criminal cases, the wrong is generally accepted as being against the state of New York. So the state of New York, the people of the state of New York, are basically entrusted to take the action as the person starting the action. The next word is vacate. Vacate means to set aside a previous order or determination. Venue. Venue is the geographical location of a legal proceeding. Wherever the case is being done, generally it's going to be in a particular county in the state of New York. That's called the venue. Voir dire. Voir dire is a legal term, and it's Latin, and it basically means in Latin to speak the truth. And a voir dire is basically the questioning of prospective jurors to determine their qualifications. So basically, they're asked questions by the attorneys for all parties to determine whether or not they speak the truth. And that's what a voir dire is. Now please, that's the end of the review that I'm going to do for this section on legal terminology. Please review this section in the manual so that you're very familiar with the words. Do the exercises beginning on page 10. If you have any questions, you may contact somebody from the Alliance about the legal terminology. I'm sure there are many people there who will be able to answer your questions about any of the legal terminology in the manual. Thank you. That concludes the end of the section on legal terminology.